is Mr. Randy Parker, Chief Executive Officer for the Utah Farm Bureau Federation from Sandy, Utah. Mr. Parker, you are now recognized for 5 minutes.
Chairman Lamborn, Ranking Member Huffman, and members of the subcommittee, thank you for calling this important hearing on the Water Rights Protection Act and inviting me to testify on behalf of the Utah Farm Bureau and 11 Western State Farm Bureaus. In addition, I want to reiterate the longstanding support of the American Farm Bureau for the Water Rights Protection Act. My name is Randy Parker, and it's an honor to be here with you today. First, I want to commend Representative Tipton for his leadership in advancing this important legislation. Uncertainty as relates to grazing and water rights has plagued livestock ranchers across the West. Passage of the Water Rights Protection Act is critical to the Western way of life and balancing states' rights and federal interest. Livestock grazing is part of the Western ecosystem. Science-based management with livestock harvesting annually renewing grasses provides for healthy ecosystems, productive wildlife habitat, economically viable and sustainable ranches, vibrant rural communities, while reducing the threat of catastrophic wildfires. Across the West, we have seen federal land managers challenging sovereignty and privately held water rights. Withdrawal of the water clause provided greater certainty for ski resorts, but for ranchers across the West, it provided little, if any, change. In the arid West, control of water means control of the land. Internal policies of both the Forest Service and BLM focus on greater control of livestock water. The Forest Service manual directs employees to claim water rights for water used by permittees, contractors, and other authorized users on the National Forest System. The Intermountain Region Forester said, the Forest Service believes water resources used to water permitted livestock on federal land are integral to the land where the livestock grazing occurs. Therefore, the United States should hold the water rights for current and future grazing, and that livestock water rights should be in the name of the United States to provide support for public land grazing programs. A quick review of the numbers contradicts that the Forest Service supports livestock grazing. Since 1949, the Forest Service has terminated or placed in non-use status 74% of Utah's historic livestock grazing AUMs. Utah's Livestock Water Rights Act already assures livestock water rights will remain pertinent to the federal grazing allotment. The BLM response to the Utah Water Rights Act protecting sovereignty and property rights is troubling. If BLM doesn't hold a livestock water right, the Utah BLM will not provide funding for new water developments nor approve cooperative range improvement projects. BLM agents are instructed to seek an ownership interest in the rancher's livestock water right or voluntary joint ownership. And finally, protest any permittee application on livestock water rights on the public lands. Utah BLM's identified goal is to hold water rights on grazing allotments into perpetuity. The agency argues privately held water rights create an administrative headache and that the permittee may attempt to use privately owned water rights to get leverage in allotment management decisions. It seems hard to argue that the federal land management agencies are committed to the future of livestock grazing, where the BLM has cut 39% of AUMs across the West. And in Utah, BLM and the Forest Service have cut or suspended 68%. Federal actions reducing grazing AUMs from 5.5 million AUMs in 1949 to less than 2 million today has led to 58% or more than 2,000 ranching families in Utah closing their doors. These de facto water rights are contrary to state water sovereignty while hurting Americans. In Tooele County, Utah, Forest Service agents told cattle ranchers if they didn't sign a change application, it could affect their turnout onto their federal grazing allotments. In Iron County, Utah, the Pearson family, seeking ownership of stock water originating on their private land, faced protests from the BLM, ultimately sidelining their claim. Ranching families across Utah have had their water rights in limbo because the Forest Service has filed more than 16,000 diligence claims in Utah. According to the Forest Service, these diligence claims are made on behalf of the United States, which was the owner of the land where the livestock grazed prior to Utah's statehood, and where the livestock watering took place, which action established the federal government's claim to the water rights. Idaho's Joyce and Lowry families, as well as Nevada's Hage family, have been nearly bankrupted because of costly battles in protecting their water rights. Congress and the Supreme Court have spoken loudly on sovereign water rights, and this act will help assure that these agencies do not bypass established state water rights systems. In conclusion, the statement of the Forest Service that was filed seems to be in conflict with the White House on this issue. Mr. Chairman and committee members, thank you, and I look forward to further discussion today.
Thank you, and all of you did an